So this is that incident I was mentioning in my interview with X-Man Rico. And this is the craziest thing that I've seen since those Four Corner Hustlers were let go after they pulled up to the crib and flamed it. And they said it was mutual combat. Zach TV, his killers were let go, man. And Chicago's court system, man, it's just crazy as far as like how soft it is. In some ways, in other ways, it's too strict, man. But anyways, this is the incident where the two guys were trying to lure children into a van. Okay, and this was actually in Cicero, in the suburb of Cicero, but it's Cook County. And they found the Cicero police found condoms, they found lube, they found a mattress in the van, and they were not detained on these charges. Okay, let me repeat that. They were trying to lure children into a van. They had all these like sex items in the back of the van, and they could not be detained on those charges because the prosecutors and the judge believed, okay, that attempted child abduction is not a detainable offense under Illinois' cashless bail system. Now, I believe that's actually incorrect. I think it is a detainable offense. But the prosecutors and the judge, they made a mistake. But, I mean, listen, man, whether or not, this is one of those situations where if I'm the judge or the prosecutor, like, I don't care what the system says. You know, if the dudes are trying to snatch children, like, I'm going to find some way to hold them. But thankfully, they did hold them on other charges. But they've been detained for violating parole and the other for violating probation. But that was the only reason that they gave that they were able to hold them. The other one, the snatching kids part, they said they couldn't hold them on that. So if it had just been that, they would have been freed, bro. And that in and of itself should be a crime. Like a prosecutor or a judge that put dudes that try to do that back on the street, they should be locked up for letting the dudes back on the street. They've been detained for all these other reasons. And if those holds are released, though, they will go home on electronic monitoring. So during an initial appearance at the 26th in California courthouse, the assistant state's attorney presented the state's allegations against the men. So one's name is Kenshi Edwards, he's 60, and the other's name is Craig McCauley, he's 55. And she told the judge, who's Susanna Ortiz, that McCauley stopped the van near 3 kids playing in an alley on 18th Street in Cicero on Friday evening. So McCauley motioned for the kids, both of them were 14, to come over to the van and ask them if they wanted to get in. Now, this happened to me when I was a kid several times. People were asking me if, I wanted to get into the car, wanted to ride and stuff like that. This used to happen a lot, and our parents always strictly warned us never to do that. But they said that a, quote, famous athlete was in the back of the van, and that he had games for them. And this is according to the official court transcript. A surveillance video allegedly recorded the interaction. So the kids, they were with a 13-year-old who did not get into the van. And the kids didn't get into the van. So McCauley drove away. So one of the kids told a parent about what happened, and the parent called the police. So Cicero cops found the van nearby, and they pulled it over. Okay, they found McCauley sitting on a mattress that was on the base of the driver's seat. And she said that Edwards was in the back of the van trying to hide things in a bag. Once the men were removed from the vehicle, police found a used crack pipe, numerous condoms, lube, and binoculars. Okay, they found open cans of Twisted Tea alcohol, an open bottle of Ice House, and an open bottle of Buchanan's Deluxe whiskey. So both men confirmed that they spoke with the children about sports and joked about Edwards resembling a famous athlete. It was the same famous athlete that McCauley allegedly told the children was in the back of the van. So they are both charged with 2 counts of child luring by a person older than 21 and 2 counts of attempted child abduction. The judge asked the state after the hearing allegations as to each defendant, are these detention eligible offenses, correct? And the state replied, no, Your Honor. And the judge said, we are going to pass this case. So how about that? Now, the transcript does not say why Ortiz took the break. When she recalled the case, though, she appeared to have received information about the state's detainable offenses. So she said, I want to know for the record as to each of these defendants, child luring and attempted child abduction are not enumerated offenses on which the people can seek detention. I want to note that attempted animal cruelty is one where detention can be sought, but not attempted child abduction. For whatever that's worth, I want that to be reflected on the record. So this is crazy, man. She proceeded to order both men to go on electronic monitoring and barred them from receiving essential movement the 48 hours per week that electronic monitoring participants are allowed to leave their homes. So, I mean, for this offense, they were going to be released on electronic monitoring. She also ordered them to have no contact with the victims, the witness, or anybody under 18. So she just gives them a verbal order. Don't have any contact with the victims. She separately, though, detained Edwards, who was a 3-time felon paroled in November, on a narcotics charge because the state lodged a hold on him while it reviews his parole status in light of the new allegations. So she detained McCauley for violating the probation sentence that he received upon pleading guilty to aggravated robbery on February 20th. So a couple of the sponsors of the Safety Act and the Cook County State's Attorney's Office were contacted by the media about this, and they said, quote, child abduction and attempted child abduction are 100% detention eligible. That's according to the Representative Cam Buckner of the 26th Ward. He said it's both named in the statute, and even if it wasn't, there's a catch-all that makes detention eligible for any felony that includes the threat or infliction of great bodily harm or disability or disfigurement. Another Safety Act sponsor, LG Sims, as he agreed, he said the allegations are more than disturbing. These allegations are exactly the type of circumstances that would allow a person to be detained under the Pretrial Fairness Act. And he said that in an emailed statement. So he said the statute is clear. Attempted child abduction should lead to detention of the accused. I don't know what this particular judge based their decision on, so I cannot comment on it. However, I do know that under the old cash bail system, a person charged with this crime would have a judge set a money bond amount. And if the person paid it, they would have been released. So this is, where the debate about the cash bail comes in. They're saying, they could have given him a cash bail and they could have paid the bond and gotten freed. Okay, but that's true. But supposedly the cash bond for something like this would have been extremely high. And so he continued. He said the facts show that overall the Safety Act, including Pretrial Fairness Act, is making significant strides in allowing Illinois to reimagine what public safety looks like in this state for the better. So that statement doesn't really mean anything, substantively, concretely. He's saying it's making significant strides in allowing Illinois to reimagine what public safety looks like. That statement doesn't mean anything. The question is would this have happened under the previous system? These guys would be on the street right now if they hadn't made that move if the one hadn't been on the parole and the other hadn't been on probation. They'd be free right now. So in an email, the state's attorney's office said we are unable to comment on the pending litigation. So you guys let me know what you think in the comment section, man. This is an example of what a lot of people have been talking about. Now, me personally, with the cash bail thing, for certain offenses, I feel like it should just be no bond set. Okay. And sometimes, they give an extremely high bond and then a very rich person pays it. For those offenses, there just should be no bond, for the kinds of offenses that could pose a danger to the public. It's up to the person to make the call, and whoever is going to potentially be paying the bond for them. And so, it is kind of a game like that, but both sides have their pluses and minuses, both situations, but this is one of the ones that definitely has to be rectified and fast. I think a lot of our laws just in general are kind of like this. However, on the other side, some of our laws are too strict, and that's a whole other conversation. I've touched on other videos, some of the stuff, some of these people are being locked up that shouldn't be locked up at all. But that's, a whole other topic for another video. But you guys let me know what you think about this, man. Your boy Chicago News. I'm out.